Welcome. Special Prosecutor Angela Carey said this week that she will not take the Trayvon Martin shooting death before a grand jury. Corey said that she continues to investigate the case and will not involve a grand jury, which is something that she apparently typically does. Meanwhile, Zimmerman's lawyers have actually withdrawn from his case, and they did it in a public manner in a news conference. My guest is retired Superior Court Judge in California, Eugene M. Hyman. He is the host of the Family Law Channel here on the Legal Broadcast Network. Judge Hyman, welcome back.
Thank you.
What possible advantage does Angela Corey get by not presenting this before a grand jury?
Well, the defense doesn't get a preview of all of the evidence in the sense that they don't get a transcript of testimony that witnesses gave before the grand jury. They're not entitled, of course, to cross-examine during a grand jury. Mm-hmm. And they would get a transcript of what everyone had to say. Now, when the process begins, if in fact it does, they'll have the opportunity to, from the very beginning, cross-examine witnesses. Mm-hmm. And there won't be a prior record for purposes of impeachment or prior record for consistent statements either. So mm-hmm. there are fewer surprises in one sense.
Now, it would seem to me, though, that this case involved a shooting death. That isn't that in a lot of states mandatory that it goes to a grand jury?
Well, apparently in Florida it is. Only if you're seeking a first-degree mm-hmm. Murder conviction. Okay. But in many states, and true in California, it's totally up to the prosecutor right. in terms of how they wish to proceed.
Okay, and so talk about why this is taking so long, because it seems like this happened now, a month ago, and now, and this is just proceeding now.
Right, and I can certainly understand because the county prosecutor recused himself, the chief of police basically has stepped down, at least temporarily, because of this case and because of how potentially his department handled it. I can certainly understand that there would be some delays because as a result of going now to the state prosecutor, she has the ability to use state investigators to reinvestigate or to search out new leads. Mm-hmm. But she certainly, in the court of public opinion, is under a great deal of pressure to mm-hmm.
Do
this as quickly as possible. And the news media, it seems to indicate that she would make a decision in terms of what she's going to do within 72 hours, and almost 24 of that 72 hours has run. Mm-hmm. So while I am concerned about the amount of delay that's occurred since mm-hmm.
Mm-hmm.
She took over the case, a certain amount of delay certainly is reasonable.
Does this indicate to you that they are short on witnesses here, or that has some sort of effect on this?
Well, possibly they might be. Well, I mean, it makes sense that they're desperately seeking witnesses because mm-hmm. Evidence in terms of proving a case can be by either direct or circumstantial evidence. Direct mm-hmm. evidence is, of course, if you were to have witnesses that were to testify in terms of what they observed. Based upon news accounts, there seems to be a rather shortage mm-hmm. of those witnesses in terms of direct observation. There's going to be witnesses in terms of what occurred later on, but in terms of the actual event itself, based upon mm-hmm. what has been stated in the news, there seems to only be two witnesses to what actually happened, and one of them, unfortunately, is deceased.
Turning to the defendant, Mr. Zimmerman, here in this case does eventually end up in trial. Why do you think his lawyers not only decided to leave him, but also do it in such a public manner?
Well, that to me is perhaps one of the more bizarre aspects of the case. It would be a different story if he had been, charges had in fact been laid and they mm-hmm. had in fact made an appearance. Then they are attorneys of record, in which case then they have to get leave of the court in order to withdraw from the case. But thus far, there is no case. Mm-hmm. They certainly have concerns that they have publicly expressed with respect to their press release in terms of that he isn't communicative. If what they're saying is true, and I have no reason to believe what they are expressing is not true, they have very good reasons for being concerned and very good reasons for withdrawing. But in terms of doing it publicly, it would appear to me that the manner in which they're doing it is, at least again in the court of public opinion, expressing some real concerns about the competency of their client, and also potentially prejudicing future jurors in terms of, does an innocent person behave this way?
Right.
Doesn't an innocent person communicate with their attorney? And also expressing concerns in terms of how he was behaving by contacting the state's attorney and voluntarily talking to the state's attorney, which on the one hand does favor the client or the potential defendant in terms of, an innocent person has nothing to fear, and they go ahead and they talk to the prosecutor, and they talk to the police. Whereas if, and the lawyers on the other hand saying, our advice is to never talk without us being present to the state's prosecutor or to the police, which, by the way, is excellent advice, but that isn't something that you would, in my opinion, discuss at a press conference.
Yeah, because it sounds like, as you said, because they had indicated, too, that they would be willing to take him on as a client again if he were to cooperate, but by removing themselves, they have really prejudiced any kind of jury. That would they be seeking a venue change, perhaps, or something like that?
Well, that's always a potential, and given how much international publicity this case has received, I think that potential is there. Of course, if they were to be very effective with respect to a motion for change of venue, they're going to have to use a research firm to ask questions of a certain percentage of potential jurors in the county. Have you heard of the case? And in your opinion, assuming that you have you in your mind expressed an opinion in terms about the guilt or innocence of Zimmerman? And if you have an opinion about this guilt or his innocence, in your opinion, can you keep an open mind about it? Those are just some of the questions that you would ask. I mean, the other questions would be, is the race of Mr. Zimmerman and the race of Mr. Martin, are those concerns for you? Those are some of the other questions that are usually asked. And, depending upon a significant response and a significant response of that response indicating that they have an opinion and that they, which is prejudicial, and that they don't have an open mind, because from my experience in terms of asking jurors, not so much even about have they read about a case. Sometimes it's just from reading the charging document, which is very inflammatory, even though a judge advises the veneer or the jury pool that these are just charges, it's not evidence. The average citizen, when they walk into a courtroom and the charging document is read, they assume it's evidence. They assume, a certain percentage of them assume, that because the prosecutor has laid those charges, that they believe they can prove beyond a reasonable doubt that that's evidence. And you spend a lot of time during the jury selection process explaining that the burden is on the prosecutor to prove the charges, and that the laying of charges in and of itself is not evidence of anything. And that, in fact, it's possible to be arrested for something which only requires probable cause to believe that a felony was committed and that the individual committed a felony, and that maybe it won't be proven beyond a reasonable doubt. Can you keep an open mind? Most people during the jury selection process, even if they come in with a closed mind, can potentially say, I hadn't thought about it that way, and given our discussion, I can keep an open mind. And a certain percentage say, no, the police think he's guilty, the DA think he's guilty, who am I to say he's not guilty?
Right.
And go from there. So it's a very charged case. Given the population of African Americans within that community, in terms of what the likelihood is that the veneer is going to be made up of African Americans, those are all factors to be considered in terms of, can this person get a fair trial?
Well, as always, you provide keen legal and judicial insight, Judge. Thank you very much.
Thank you.
And thanks for watching the Legal Broadcast Network.